take over the other 6 minutes and present some of our empirical results so far. So let's start. Oh, that doesn't start. Yeah. So why are we looking at priority setting, and what do we mean by priority setting? We define priority setting as the freedom of competition authorities to implicitly or explicitly decide whether they pursue a case or they disregard it. So it is very much about the exercise of administrative discretion to select practices they want to investigate and start proceedings. In the project, we look at procedural rules, which has been quite a challenge. I will tell you a little bit more about it. Administrative procedures, sometimes also to criminal procedure, substantive criteria of priority setting, and we also look at the institutional setting, what kind of institutions, what is the institutional design of competition authorities, and within the institutions, the kind of body that takes that decision. We look at, if you are more familiar with some of the literature on priority setting, we look at both positive and negative priority setting. So both setting positively goals, what priorities should be for a competition authority, as well as rejecting complaints. Now, why is this important to have a look at? There is obviously a very strong economic reason. Competition authorities cannot do everything. They have limited human, financial, and technical resources, so they need to rationalize their enforcement. I think that might be one of the first reasons you would think about. What we also see, and as we further in the research more and more, is that there are also very crucial legal and political reasons, and mostly related to questions of good governance and good administration. So law enforcement, competition law enforcement has to be legitimate, and with priority setting, competition authorities can show that they enforce the law legitimately. It is a crucial aspect of also of being independent, independently being able so without undue political interference or interference from the market, independently set the goals, the priorities for the competition authority. Independence, however, does not go without some kind of control, and that's also what we very much see, that there are also fundamental questions of accountability. So once these authorities are allowed or do set priorities, how the law or politics can hold them to account and ask questions of why did you do that, and why didn't you pursue another case. So it brings in and enforces principles of transparency, and arguably it makes competition authorities more credible while also giving them flexibility. And just to give you an example about good governance, when we were talking to the Swedish Competition Authority, we were already talking for an hour when it occurred to us that while their system does not seem to be, well, let's say it now very quickly, legitimate, accountable to us, while we know about the Swedish legal system and political system, that they put a lot of emphasis on transparency, etc. And then it turned out that there is a much more general public administrative act, which obliges all administrative authorities to comply with principles of good governance. So here you go, there was nothing specifically in the Competition Act, because this overall constitutional administrative law framework has set the scene. And that gives me also a step to talk about some of the crucial issues that we see. And maybe it's also good to emphasize that we have prepared a very slim presentation for today, so I can see that there are many things that we will not talk about, so feel free to comment or ask about it. So I mentioned a few things that we see as implications and important issues we investigate and will be investigating. I already mentioned the priority setting is in fact the exercise of administrative discretion on the side of the competition authorities. So it is an exercise wherein they concretize directives that stem from the legal norms. And this is a freedom which this discretionary power gives them the freedom to choose between different alternatives. And why this is good, because they can select priorities. It also very much touches upon what kind of public interest they take into account, how they balance public interests when they concretize legal norms. And this selectivity, while being, I think we look at it as being a good thing, there are also certain risks in that. Being selective in which cases to pursue also inherently has the risk that there might be under-enforcement of certain practices which are in the law and in the legal norms, or even non-enforcement. And there, so the risk might be that an administrative authority would sit or have powers of a legislator and changing the scope, the focus of the original focus of the laws. I will not go on more about this, but I think this is in itself is a fascinating topic. So we do see that, and we also look at and research what are the legal, political, internal, external controls on priority setting practices of the competition authorities. Now, why is this a fascinating study? It's because I think we probably didn't think about it when we started, but we are becoming experts in almost 20.
Mamma, sto a sentire una cosa.
Oh, that's probably not a remark for us. So we see that our study very deeply cuts into the different administrative law traditions and current laws of the member states, and the way priority setting has been given form and the degree of discretion on the side of the competition authorities reflects this long-standing tradition in national legal orders. Fascinating in itself, and certainly a topic for itself, but I will move on now. And just probably most of you know the EU law framework, but let's put it up here very shortly so that we can show that where our project started. So if we think about the EU law framework now and what has been laid down in EU law, then looking at the system, the centralized system before 2004, we see that, well, it's largely about the Commission's enforcement, of course, where the Commission's opportunity to develop a positive priority setting practice has been limited by the fact that it had to deal with notifications and complaints. But what we also know and see is that this negative priority setting practice has been, I would say, nicely worked out and legally framed by the court. So the case law which developed from the Otomec 2 case and so on, they are fundamental issues and legal principles, how law and EU law frames and controls the Commission's discretion when it rejects complaints. So from the idea that it has to look at the complaint to probably the most important issue of it has to give also reasons why it rejects the complaints and what kind of judicial appeal is possible. Now, oh, sorry, I went the wrong, how do I, yes. From 2000,
you think of it about the time?
10 minutes you mean, or my 6 minutes?
Think of it about the time, I think you are only the first half of the presentation.
Yeah,
I have understood.
so I will finish off here now. So with decentralization, the Commission did have the possibility to refocus its activities, but then we have the second layer of the national competition law enforcement, where the national administrative laws step in within this multi-level governance system. And this is where, sorry, wrong way. This is where the ECM Plus directive comes in, which now lays down very specific obligations for the member states and the competition authorities to set their priorities to be able to reject complaints. And this is my last sentence, and then I give the word to Or, where our project comes in, that there is no guidance and actually no helping tools either in EU law, in the hard law or in the soft law, how how to set priorities. So what kind of procedure or substantive criteria to follow. And this is where our project starts.
Yeah, so one of the most difficult parts of our project was to identify actually a theoretical framework to discuss different aspects of priority setting. There's no accepted terminology, and various aspects of priority setting are governed only in some member states, but not in others. I think, Kati, next slide. Yeah. In this paper, therefore, we offer a theoretical framework to study priority setting, which identifies 7 different aspects of priority setting, which we study empirically. This theoretical framework and the gathering of information was based on interviews and questionnaires that we had conducted in the last 2 years or so with officials of all 28 competition authorities, and followed by a desk study of the relevant administrative and institutional national frameworks of all 28 national competition authorities. And this project is also funded by the ESRC funding. Those 7 aspects, and this is what we're going to end the presentation with, can be classified into 3 groups. Priority setting, which is taking place in the pre-decision stage, during the decision stage, and post-decision stage. So the first aspect of priority setting that we identify in the pre-decision stage is agenda setting. When we say agenda setting, we mean that competition authorities can publish a periodic list of specific sectors or specific practices that they flag as a priority. Our study found that around 2/3 of the competition authorities publish those agenda every year or every few years, but we can see a difference in the way that they adopt those agenda. Some competition authorities adopt agenda in their own motions, here in the orange, while others are required to do so by law, and some of them are even required to report the agenda to the government or the parliament. The second aspect of priority setting that we identify is the jure competence. And this is probably one of the most main issues of priority setting. This graph showed that not all competition authorities have the same power to set their priorities. Some competition authorities, which are marked in red here, are bound by the legality principle, meaning that they must investigate every case that comes to their attention, and they have very limited discretion not to investigate cases. Other, marked in green, have full powers to choose cases on any basis, while we have the middle category in yellow, which are bound to a public interest criterion, meaning they can decide not to enforce a case if there is no public interest in doing so. The empirical findings also show that the competence to set priorities is often limited when it comes to rejecting complaints, and that's the right-hand side. This is about to change following the implementation of the ECN Plus directive, as you asked, Vicky, which provide that competition authorities should have the power to reject complaints. However, the directive only referred to this aspect of priority setting and not to other types. The third aspect of priority setting is the de facto competence. So of course, and that will not be a surprise, that priority setting is not only about substantive rules or de facto competences, but also about more practical issues like budget, HR, and institutional capabilities. Moving to the decisional stage, the fourth aspect is the procedure. And our research shows that there are considerable differences in the procedures to set priorities in each one of the competition authorities. The competition authorities differ in the body that's taking the decision. So some have a designated priority setting unit, some have a designated meeting of management, and some of them are actually, it's being settled in the case handler level, so quite low in the authority. There's also special systems like Greece, for example, where there's a point system to decide whether or not to take a case on the grounds of priority. The authorities also differ in the need to provide reasoning and publish the decision. What is interesting about this aspect that the procedure is often governed by national constitutional or administrative law rather than on competition law, as Kati mentioned. Despite that, the study showed that the procedure often impacts the type of cases being pursued, and that it had a lot of impact in the portfolio of cases of each authority. The fifth aspect is the substantive criteria. So while EU law does not provide guidance on how to select cases, our findings show that around 80% of the competition authorities have adopted substantive rules to guide their priority setting. The word cloud summarized the type of criteria that was adopted internally by competition authorities. Due to time, I will just mention a few. So you can see that seriousness of infringement is one big issue, impact in market or consumer welfare. But there's also things like whether the competition authority is well placed, would the enforcement be effective, and so on. The sixth, so moving to the post-decision, sorry, we're still in decision stage. The sixth aspect is instrument and outcome discretion. So we also see the selection of enforcement instruments, like whether to handle a case by leniency, settlements, commitments, or a warning letter, is also one aspect of priority setting, and still differ considerably between the member states. And finally, the seventh aspect is a post-decisional stage. And we can see that in a relatively small number of competition authorities, they must undertake an impact assessment to evaluate their priority setting decisions. But we can see that it's done in very few member states, and in most cases, there is no assessment of the effectiveness of the selection of priority. So this was kind of, you can move to the last slide, I think. This was a very quick summary of our ongoing project. For more details, follow our social media and stay tuned for a policy report that we hope to publish towards fall. We will have a priority setting workshop that was supposed to take place in May, but we'll schedule it to fall or winter, and training seminars for national competition authorities. So if you are interested, please get in touch. Hope
Okay.
time.
Thank you so much for this presentation. I have several questions. Vicky Robertson, I will put you on. Sorry.
Hi, shall I just go ahead and ask?
Yeah,
yes,
fine.
because I haven't read it.
Okay, sure. So my question was basically, you've done that research now, and I think it would be really interesting to see how or if this changes after the ECN Plus directive has actually been transposed, especially in those countries that you showed where there is not so much priority setting options so far. So that's my question for you.
How it will change after the directive?
The legal framework for the authorities might change.
We do study that. So, I mean, the deadline for the implementation is the January 2021, so it's pretty close. And it is something we definitely follow, and we can see some changes already.
Okay.
But I think we also have to say that, at least we haven't discussed this, but I think that there are a few countries who seriously think about it, changes, but I think we could show also cases where there won't be changes. So I'm not sure if the directive itself will have a great impact in that we will see now very structured and well worked out priority strategies.
Mm. But your study might help in this.
Yes, that's what we hope.
Okay, thank you. I think we have one question from Ruprecht.
Yeah, thank you. I just wonder whether you sort of distinguish between, or I think I've learned that you distinguish between public priority setting, so that what you communicate to the outside world, and internal moves. And I can well imagine that it's very important and vital what you do internally. But I wonder what's your assessment of the more external priority setting, whether that is something of value or whether it just serves to write up fancy reports that congratulate yourself for reaching all your goals. And the background to my question is that I have the impression that particularly with the EU Commission, I often have the impression that it's so vague what they have in their priorities that they can basically do everything with it and even handle it that way.
Can I take that?
Oh, okay.
Do you refer to the agenda setting? So what they flag out as the agenda? I think it really differs from one member state to another. So some seem to take it very seriously, while others acknowledge that in the end, they just don't have resources, so they only look at complaints, or they only mostly take leniency. So it really differs, but there are definitely some jurisdictions that do. And to this end, having the interviews helped a lot. So we had anonymous interviews. It felt like people were honest.
Yeah, but I think I want to add something, because this was also with many competition authorities. When we started talking, they started about their agenda. Like we focus on digital markets, we focus on electricity, energy transition, etc. But I think that's much more in the on the spotlight. But the question of how you decide when you get the information from as the authority, you have to sieve it, and then you decide whether this is worth for me to take the decision. I think it's much less outside there. I actually had the feeling that when we were talking to them, some of them realized, well, is this that they had some kind of internal procedure, but maybe they have not been so conscious of it. And I think this is a lot less out there with a few, for example, the Latvian Competition Authority came up with a model which is out there in the public domain in 2015, but you see very little of these specific models or documents or reports being publicly held. And I think most of them would not have that, but that's not the same as their agenda.
Okay, thanks. We have another one from Maciek Bernard. I'll try to find him.
Hi, Maciek.
Okay. Hi.
Hiya.
If I can ask again. Hi, Kathy. Hi, or I like
Hi.
the presentation a lot. So let me just ask kind of a normative question. I'm wondering what's your maybe starting point or a point in which you are. Do you believe that prioritization should be encouraged? Because this is something that ECN Plus seems to do, right? And if yes, whether you see any risks related to prioritization, in particular as far as rejection of complaints are concerned. So what's your, how do you like it or not?
I would say I think it's inevitable. So I mean, and especially when we spoke to competition authorities, you always need to prioritize cases. And I think there was no authority, or maybe one authority, which said that it's not an issue. All of them need to, because of budgets, because of internal resources, and it makes sense. So what we are trying to advocate is, because we know that everyone will need to prioritize, let's try to do it in a way which promotes good governance, which promotes a balanced portfolio of cases, which relates to effectiveness and deterrence and so on. While now, at least in some competition authorities, it feels like it's been done a bit arbitrary or a bit on the go. So there's no rationale behind it. So, Kathy, if you want to add.
Yeah. Do I understand? This will be, I think, the last one that we answer, because the Wolfgang wants to move on.
Yeah.
I'm sorry, this is probably the countries where we come from. I can also see in your question another question whether countries could hide behind saying, well, we have a prioritization strategy. Yeah. This is how we do it. We will do things right for consumers, but then we leave the cartels in the bank sector and where our friends are. I think that risk is very potential. So in that sense, I think I of course agree with Or. I think our research is going to be crucial to see what is out there and probably giving recommendations what ways you can do it, but that will never take away that political game behind that. And in fact, Hungary has a very good one.
Yeah.
Thank you.
Okay, thank you so much. Thank you, Kathy, thank you all. I think we should go now to Ben, and who is represent about the European Commission's handling of non-priority antitrust complaints. So perhaps one last comment from me for the last thing is, from an economic perspective, when we think about priority setting, I could have also the idea that we are asking about an efficient allocation of resources in respect really to increasing consumer welfare. So if you see consumer welfare as a kind of an goal, then we could also think from this perspective. I know this is not what it's done, but I think it would be perhaps an interesting aspect. But now Ben really should continue with his presentation.
Many thanks, Wolfgang. Everyone can see the slides?
Yeah.
Yes. Okay, great. Thanks. It's really nice to be on this panel. The paper I'm presenting today is output of a research project that I've been working on and off for quite some time now, which basically was triggered by two events. I guess, as was just discussed, the ECN Plus directive. As a result, all NCAs will share the power with the commission, will have the power like the commission to reject complaints on priority grounds. And as Or and Kati nicely illustrated, there's a wide variety of practices and policies also as regards negative priority setting at the national level. And I guess after the directive that will remain various procedural institutional options. And it struck me that there's so little research. that the topic of questions about what implications such choices have for incentivizing good complaints, relevant complaints, it is very much underexplored. So that was trigger one. But I'm very happy with the research of Katja and Or, so that's a huge contribution. Secondly, on a more personal note, in June 2014, I filed a complaint on behalf of 2 Dutch speed skaters with the Commission against their International Sports Federation. Now I can tell you sports is definitely not a priority sector for the European Commission. And we realized that probably that complaint would be rejected. So we started a social media campaign to reach out to the commissioner with an open letter trying to convince her of the importance of the case. And due to a fortunate turn of events, an investigation was opened. And in the end, we got a prohibition decision because the commissioner took a personal interest. Now, I was very happy with that development. But it also learned me that priority setting and negative priority setting is very much a black box at the commissions, at the very least, or even a mystery box. You don't really know what you're going to get when you file a complaint. So I wanted to scrutinize the commission's long-standing experiences with dealing with or exercising its discretion to reject complaints on priority grounds. And I wanted to look at the practical implementation. So that's the empirical assessment part of the paper. Just very briefly, I should emphasize, as probably you all know, complainants cannot trigger an actual antitrust investigation. So the Commission has a very wide discretion, almost unfettered discretion in deciding whether it picks up a complaint or not. The only limits are it has to carefully consider all matters of fact and law, and the complainant is entitled to receive, in the end, a definitive decision rejecting the complaint. Now, there's essentially 2 grounds which the Commission can invoke to reject a complaint. So one is there's insufficient grounds for acting. And since the Automec 2 judgment, we know that the Commission can refer to the EU interest in that regard. In the paper, I discuss all the case law that does put some conditions on the criteria the Commission may use here. And the second ground is that an NCA is dealing or has dealt with the same case. And that's a ground introduced by Regulation 1/2003. So if the Commission were to decide to reject a complaint on one of these grounds, then this is the procedure. During a first stage, the Commission will examine the complaint. And then if it comes to the preliminary review that the complaint should be rejected on priority grounds, it will inform the complainant thereof. And then the complainant can withdraw its complaint. If not, the Commission will proceed to produce an Article 7.1 rejection letter, and then potentially start stage 2. During stage 2, a complainant, but stage 2 is only triggered if a complainant makes written observation to the letter. Then the Commission will take into account these observations. If it doesn't alter its proposed course of action, and spoiler alert, it never does, the Commission will proceed to adopt a formal rejection decision. If a rejection is done on the basis that an NCA has dealt with the case, the procedure is the same, but you don't have a formal pre-rejection letter. There's only some form of communication of its intention to reject a complaint. So that's the procedure. Now, how does it work in practice? As I said, I wanted to unpack this black box. So I wanted to do a survey quantitatively and qualitatively of all the rejection letters and rejection decisions the Commission has taken since 2004 when this new complaint system came about. That was a challenge because I noticed quite quickly that only a selection of decisions were published online. And DG Comp was unable to provide me with a list of all the letters, case numbers, all the decisions. So I had to retrieve that overview from the Register of Commission Documents. And then I had to bombard DG Comp with over 100 access to documents requests, which was a painstaking process. But in the end, I have a unique data set which includes all formal rejection decisions that the Commission has taken over a period of 10 years from 1 January 2009 to January 2019. And the paper focuses on my empirical findings regarding that data set. So essentially, this is the data set. the Commission adopted in this period 72 rejection decisions and 144 pre-rejection letters, with a remarkable peak in 2014 when Commissioner Vestager took office. So there might have been some clearing of a backlog of pending complaints there. Now, what do these numbers tell us? Well, DG Comp says it receives about 45 formal complaints a year. So some of them, of course, trigger an investigation, Spotify comes to mind. But the majority of them are actually voluntarily withdrawn by the complainant because they are informally rejected by the Commission. It's only in about 30% of all the complaints that a pre-rejection letter comes about. And then only in half of these cases, the complainant is so insistent that a rejection decision is taken. So the rejection decisions are a small subset of the entire amount of complaints that the Commission receives. So I couldn't possibly make any statistical claims about the types of complaints the Commission gets, but rather my focus is on the process and procedure. And there, all the rejection decisions in the reference period are a reliable and really the only primary data source. So I will share with you some 3 key findings, key takeaways, 3 gaps also that I identified in the paper between the principles and the rules and the procedures and then their actual implementation, so the law in action. And I derived some lessons from that about the incentives or disincentives given to complainants. Now, first of all, regarding the duration of the procedure, well, it's fair to say that that duration is excessive. On average, the proceedings, so starting from the filing of the complaint up to adopting a rejection decision, takes about 31 months. So that or 34 months, sorry, on average. So that's almost 3 years to really go through stage 1 and stage 2. So stage 1 on average is about 23 months, and stage 2 lasts on average 11 months. Now, the Commission, this sits at odds with what the Commission says it is in its notice on handling of complaints. There it says that the complainant will be informed about the fate of its complaint within 4 months, at least an indication. But in the data set, only in 2 cases, actually, the complainant received a pre-rejection letter within that time limit. So the Commission does indicate, of course, if the investigation is complex, it might take more time. So therefore, I distinguished those cases in which investigatory measures were taken. Taking out supposedly the more complex cases, but you'll see that the average duration of the first stage is still very high, only marginally shorter. If you look at rejection of complaints on the basis that an NCA is dealing or has dealt with the case, the duration is less, which is unsurprising because the Commission only needs to ascertain whether that case has actually been dealt with. Now, I can be frank, in most cases, there doesn't appear to be any other reason for this long delay, a consistent delay, rather than to kick the need to draft a rejection decision, which of course does take time and resources in the end. So it's a long waiting game for a complainant to actually get something that they could appeal to the EU courts. In the paper, I discussed 2 remedies available to complainants, so an action for failure to act or go to the ombudsman. But maybe afterwards I can discuss, I mean, these are of very limited practical value. And I've given it long thought, and I really do think that actually we should have more binding time limits on, for this process as we have in the field of state aid law. The second point regarding the evidentiary burden on the complainant, one observation is complainants should be made aware, I think, that the evidentiary burden is actually quite high. The Commission takes a strict view of the types of evidence that the complainant needs to put forward, much higher than what the admissibility conditions would suggest. And as you can see here, so these are the grounds that the Commission invokes for rejecting a complaint. The likelihood of establishing an infringement is by far the mostly invoked ground in about 73% of the cases. which is then closely related to the finding that the scope and complexity of the investigation required would be disproportional. So it's important to keep in mind that I also looked at the types of investigatory measures the Commission takes before deciding not to open a full-blown investigation. And in half of the cases, nothing like that happens. There's no investigatory measures whatsoever. So it's really the complainant that has to produce all the evidence. In 30% of the cases, the Commission takes formal investigatory measures, but that's mostly RFIs, requests for information to the targeted party. But interestingly, in 39% of the cases, the Commission does send the complaint to the targeted party for comments. And in some units of DG Comp, this is a routine first step. A complaint is received, non-confidential version is requested, and then it goes on to the targeted party. I do have some issues with that because I wonder why is it then not standard practice for all units? And also it does make the whole process rather adversarial instead of inquisitorial, and gives certainly a strategic information advantage to the targeted party. And then the last point, because I'm running out of time, I see, regarding the transparency of the procedure. We just had started that discussion to what extent should all of these things be publicized. Well, I should note the Commission in its best practices notice says it will publish all rejection decisions. Well, when I started my research, less than half of all the decisions were published. And it was actually my requests for access to documents which prompted DG Comp then to suddenly publish all of these old rejection decisions. So now most of them have been published, but 41% remain unpublished, and it's unclear to me why, but I'm happy to see that my research already had some form of impact. And then one last point on transparency, because priority setting, this negative priority setting, it's very much also in a broader sense intransparent. All of these criteria that the Commission can invoke, it's a lack of EU interest is such a malleable concept. And sometimes these criteria can support diametrically opposing conclusions. So it's very difficult for a complainant to anticipate the potential success of its complaint, particularly when the Commission, based on the case allocation rules, would seem to be the well-placed authority to deal with the matter. So it's very much a guessing game, and it's a tricky one, because if you file a complaint with the wrong authority, who then rejects it on priority grounds, then that can actually settle the fate of your complaint, because others then can also reject it just solely on that particular ground. So perhaps indeed, you find some prioritization criteria if you go look at the annual management reports of DG Comp, but they're hidden somewhere on the website. I end the paper with a plea that at least some form or more transparency would be very welcome in this regard.
Okay, thank you very much, Ben. I think we have some questions, first from Marcin Kaminski.
Well, it's not even a question, just a quick remark about the Article 10 decision. As far as I know, there hasn't been any Article 10 decision. Is it correct? I mean, non-applicability decision. So.
Yes, that is correct. But I think now, in the context of the crisis, that the Commission did write a sort of comfort letter. I'm not sure if it's formally Article 10, but yes, that didn't happen before the crisis for sure. Yeah.
Okay, then Brock, you had a question.
No, it wasn't a question, it was a compliment. I think it's an amazing project, and I think even the fact that they published the rejection complaints because of that is a great outcome in itself.
Thanks.
Congratulations.
Okay, Caddy, you wanted?
Yes, I had, this is maybe a side issue. I was wondering whether you have seen from the rejection letters, to what extent consumers or consumer organizations lodge complaints. That's one question. And I have another small question to your very last slide. So in fact, the lack of EU interest, you mean the union interest as it is laid down in the regulations and the guidance, this is not really is it more procedural or substantive criteria that they reject, or there is, I don't see that slide anymore, but I was wondering what you make of it, because you said it's very inconsistent, but still, can we make something of it? Is it, you know, if somebody would want to file a complaint, do I have to get my thing together in terms of procedure, that I will provide the evidence, or what is it that should be in there?
I'll take the last question first. It's very much uncertain. So surely, yes, there should be sufficient amount of evidence, because if you do not support, for example, with evidence, the market definition that you propose, or the finding of the alleged finding of dominance, then the Commission will readily say, the likelihood of establishing an abuse is very low, because we don't even have the evidence to find dominance. So it really stops there. So there should be sufficient evidence to back up the claim. On the other hand, if the Commission wants to do a case, this shouldn't be a deal breaker. So then it does engage in investigatory measures. As to the criteria, it can really work both ways. I don't think that the list of criteria you find in the manual of procedures or in the notice really help you all that much to see whether you tick many boxes. There surely should be a cross-border element, but apart from that, like likelihood of establishing an infringement or precedential value, these are very, loose criteria. So in that sense, I find it difficult for a complainant to really look at the checklist to see how the complaint would do. So my advice would be take the phone and call ahead.
It's interesting in the sense. Oh, sorry, I will write it down.
Okay, cool.
Okay, thank you so much, Ben. And now we have a second presenter about rejection of complaints, at Marcin Kamiński from University of Warsaw. Please.
Yes, have I just unmuted myself? Do you hear me?
Yes, we hear you.
I beg your pardon, I'm very sorry, but apparently my camera just decided not to cooperate with me today. So I connected with phone, so somewhere there should be my image available. So yeah, sorry for these technical problems. But I will try to stick to the 12 minutes requirements and deal with the topic of the rejection of complaints, which is very much related to Ben's presentation. But I will take a question, very interesting question, at least from my point of view. Is it a mere formality to reject a complaint? And I will try to deal with this very much persisting conviction that this is a very formal requirement and not a practical one. And I would also like to draw some lessons for digital market operators. So firstly, and this is my main thesis, is that it's not a mere formality whatsoever. There is a huge discretion granted to the Commission and now to national competition authorities, but it's not only a mere formality, and there are some requirements that the Commission has to fulfill. Then, well, I would like to explain, so I presume that most of you perfectly know it, but still the EU interest, which is the main topic and the main reason why we are talking about the discretion, was acclaimed in this Automec 2 judgment. And in this judgment, the court just stated that the Commission is entitled to pursue its and set and pursue its policy objectives. So in this regard, the Commission is also entitled to reject a complaint just because it's not within, it doesn't fit to its policy objectives. And the jurisprudence evolved, and it came even to the conclusion in the case, I believe it's Oli de France, it's only in French, that even if the Commission is convinced that there was an infringement, nevertheless, the Commission is not obliged to investigate the case. So we've got an infringement, but still there is no obligation to issue a final decision. And we may take this EU interest issue from two perspectives. I believe they were even briefly presented by Or and Kati. So the first perspective is the Commission's perspective. So the Commission is very much interested to pursue its policy objectives. It would constitute a very high administrative burden just to investigate each of the complaints, but I do believe that that's the case in at least some member states. But apart from these rights granted to the Commission is also obliged to state reasons for rejecting the complaints. And from the other perspectives, from the complainant's perspectives, we've got rights granted and stipulated in the regulations, mainly the right to be informed, and it means to be informed of the reasons why the Commission rejects a complaint, but there's no right to obtain a final decision. I mean, final decision of the existence or non-existence of an infringement. And bear in mind these two perspectives and also the jurisprudence. I observe that there's a conviction that still this is a formality. The Commission is vested with a huge discretion and might reject any complaint due to very blurrily presented reasons, and well, this decision will not be appealed or just will still be valid. But there are at least some indications in the jurisprudence that it's not only a formality, but also the requirements set in law and also in jurisprudence are very much important. So the first and general requirement is requirement even stemming from the Article 190 of the treaty, the requirement to state reasons. But still, it's not the requirement to state any reasons. The reasoning has to be provided, and also the reasoning has to be sufficient and take into account all of the relevant factors. And while it was there somewhere in the jurisprudence, it didn't have such an important practical impact until the judgment in 2010, CEAHR judgment, when the Commission rejected the complaint, substantiated this decision, departed from the evidence and the conclusions provided by the complainant, did it and or just stated reasons for rejecting a complaint which were not sufficient and which were not substantiated. And this final judgment just sprung the debate and also some claims that, well, finally there's the real obligation, and we've just seen the other face of this obligation. So the requirement to state reason is there as very much vivid and is very much important for any rejection decision. So this is the first point, that the requirement for stating the reasons is very important, also from the practical point of view. The second point is that as even Ben showed, that normally it is for the complainant to provide evidence. But the Commission may not simply overlook evidence. The Commission is not required to comment on each evidence provided, but still the Commission may not just simply overlook, skip, or omit the evidence, which was the case in this micro-leader case, when the Commission just overlooked the indications or the evidence concerning pricing policy. So it's very much important that if the complainant decides to issue a complaint and provide an empirical evidence, in particular concerning pricing, well, then the Commission has to deal with this evidence. And if you obtain the rejection decision, then, well, maybe it's a good idea just to appeal based on or just check whether the Commission really assessed this evidence. And well, in micro-leader case, this error made by the Commission was very costly, and finally the decision was declared invalid. And thirdly, also the Commission investigates the significance of alleged infringements. So the Commission is perfectly entitled just to claim that it's not significant, but still it's required, firstly, to see how serious the alleged infringements are. And even if a company, an undertaking, ceases to apply these practices, still the Commission is required to see and examine the effects of these practices. And this was the case in UFEX case, when the Commission did not examine the effects of alleged infringement, which also led to the declaration that the decision is invalid. So these are only three main points and three main requirements which are there and are important, but there are also some lessons and conclusions which might be drawn for digital market operators. So firstly, be aware of the rights, and foremost, be aware of the obligations imposed on the Commission. Secondly, still, the Commission has a very significant discretion, so it wouldn't be a revolutionary step just to dwell into the obligations of the Commission. Still, even the Commission, if it states properly its reasons, is very much entitled to reject a complaint. Thirdly, there is a very important role of ECN Plus directive and the issue of negative prioritization. So if now I believe that all NCAs will be vested with the right to set negative priorities, then I believe that NCAs should follow the rules imposed on the Commission by the court, and may not just, for example, simply overlook evidence. They should follow some strict rules for the rejection of complaints. And finally, be careful and be cautious. And it's a very recent press release concerning Upstore case, which the Commission decided to investigate based on the complaints, but the Commission indicated that, well, maybe this will be the case of applying Article 101. So in this situation, it might be the case that the complainants might receive the final decision, but it wouldn't be a rejection decision or the decision it's expected, but it would be an infringement decision. So be careful with complaints. So thank you very much for your attention, and I'm here to take any questions.
Thank you so much, Martin. Yeah, there's a number of contributions in the chat, but it's not quite easy for me to understand whether they are really questions to the audience or more a general discussion between the participants. Who would like to?
I do have a question,
Okay.
if I may. Walter.
Yeah, please.
Thanks, many thanks, Martin. I was actually wondering if you were given the opportunity to redesign the European Commission's complaint procedure, what would you change?
Well, that's an excellent question. So firstly, I would refer to your presentation, your remarks concerning the first stage of the investigation, when the very first decision of the Commission is just to transfer the complaint to a targeted company. I've got some doubts about it, mainly that this is the very first step, also very discouraging for the complainants. Sometimes, well, maybe there is an infringement, but you might decide not to issue a complaint, bearing in mind the very important relation with, for example, dominant company. So this is the first remark. And secondly, I would love to see some indications about the prioritization. So maybe the Commission, well, we've got some kind of prioritization in soft law, but maybe the Commission should be required at least to state which kind of cases are not within the EU interest whatsoever. Then the complainant will just not be entitled to issue this kind of complaints and will go to national competition authorities and not deal with the Commission. And it would make this whole system more clear and transparent.
Thank you so much. I also have a question both to Ben and to Marcin about, so I'm an economist, so I come very much from the outside, and therefore the question was, what is the role of the complaints at all in the enforcement system? So is it about really the complainants, because their rights are somehow, there's infringement, or is it really about that the whole enforcement regime gets information from complainants? And the information is perhaps very important for the question whether there should be an investigation or not. So in that respect, it would be also interesting to ask the other question, not about the rejection of complaints, but the question, so how many investigations would not really be triggered if there would not be complaints? So how many of the investigations are really based on complaints? Because the interesting thing is what is really the role of the complaints at all in the whole enforcement system. I don't know, Ben, Martin, who would like to?
Yeah, if I may, I think it would be very interesting to know. Unfortunately, that's not publicly known. You know, how many complaints trigger an investigation, how many are voluntarily withdrawn. I can only say how many are formally rejected. Yeah. So it would be interesting to see how many are successful in that sense. But how important are complaints? I guess it's a big debate to what extent competition authorities should be reactive or should invest in doing market studies and start investigations ex officio. I guess the whole idea was, when decentralization happened in 2004, that the Commission was afraid that there would be an information gap because you didn't have the notification anymore. So therefore, he wanted to encourage complainants to come forward, as happens with the leniency program, obviously. So yes, I mean, I think its own measurement is that the system should produce high quality complaints. And that is, but to what extent it should be complaint driven, or to what extent the authority itself should pick its targets, I guess that's a discretionary choice. So unfortunately, I don't have the percentages. I think
Okay.
most antitrust cases from the Commission are not complaint-driven.
Okay, thanks.
I
Martin?
would also only add the importance of the economic evidence. So I would just claim that without any economic evidence, the Commission would be very reluctant to take a case, or take an investigation. So we really have to properly prepare a complaint to have a slight chance of being accepted.
Okay, thank you so much. Then I would suggest that we go to our next presenter. That's Eugenio Almeida Peralta about are we bargaining good deals?
Mm-hmm. Yes, 1 minute. I am going to share my presentation. Well, first I begin, I would like to recognize and to give thanks to the organizers of this conference for the terrific work they have done in this month to keep it on, even when we cannot be in Portugal today. I hope next year we will meet in the beautiful Porto. So I am very glad to be in this table because my topic deals directly with the things that my colleagues have already talked about. I am going to talk about the use of settlements that the European Commission is doing, and this has much to do with, not much with prioritization, but with the discretionality of the competition authorities. As we all know, in the European Union, the European Commission introduced the settlement procedure by means of the Regulation 622 of the year 2008. And then we have a Commission notice on the conduction of this proceeding, and also a press release and frequent asked questions. There we have how can I say, the basics, the legal base of this instrument. But however, 10 years later, the first decisions were taken. The first decision was taken in 2010, was in the case of animal feed phosphate cartel. 10 years later, we have to assess what use is doing the European Commission of this instrument and how could it be improved. If we go to the data, we can see that in this period of 10 years, since 2010, 31 cartel cases have been closed after a settlement agreement that represents 63% of the total cartel cases. I am only considering cartel cases because in the for the European Commission, the only cases that can be handled under the settlement proceeding are the ones of cartels. So we are not taking into account Article 102. And we have an average of 3 cartel cases that are handled under the settlement proceeding per year. This means that we have a historic high of 8 settlements taken in the year 2014 and an historic low of only 1 settlement in 2012. But we can see that in the last years, there is an increasing use of this instrument. In 2018, we have that the 25% of cartel files were decided by a settlement decision, by an agreement with the parties. And in 2019, all cartel cases were decided by means of an agreement, a settlement agreement. So we have to take into account, if we want to improve or to assess what is the current situation of the settlement proceeding in the European Union, we have to take into account a critical and comparative assessment of the procedure. And this is quite difficult because the European Commission has stated in many cases that the European settlement is a unique proceeding that cannot be compared with other forms of settlements, such as the plea agreements in the USA or the old French procedure of non-contestation de griefs that has already been modified and that currently, nowadays, it seems it is more likely to the European Commission model. If we want to, this is a bit of a background, if we want to consider what settlements are, it is very difficult to give a definition of settlements because every jurisdiction has its very own configuration, has its very own definition, and there are significant differences between jurisdictions. However, if we want to go to the minimum common base, we can say that settlements are an enforcement instrument that allows to streamline the handling of competition law cases by means of an agreement between the competition authority and the infringers. If we say so, this is a kind of a cooperative enforcement, and such as it happens with other instruments, such as the commitment decisions, we need the cooperation of the infringers with the authority. And the common base of these settlements all over the world, or in most of the jurisdictions, is that we need, on the one side, that the parties, that the cartelists, do not oppose to the charge faced by the authority, or they do acknowledge the infringement. In exchange of that, they may receive a fine reduction or a better judgment in the cases of criminal prosecution. The general features are that they are based on a voluntary base. This means that the parties may decide if they want to accept the settlement agreement or not, and that the authority has also the discretionality to choose if it wants to conduct a certain proceeding under the way of the settlements or not, or if they want to continue the ordinary proceeding. Any settlement proceeding implies the need to waive to certain procedural rights. For example, the right to have a formal charges, because they receive only a simplified statement of objections, the right not to self-incriminate, the right to oral hearings, the right to challenge the decision, and this may be the most relevant waiver of the parties, the right not to, the refusal to challenge the final decision, and linguistic rights that in jurisdictions such as the European Union, where we have many different languages of all the different member states, could be of great interest. We need, for this system to work, we need some requirements: transparency, predictability, certainty, and the confidentiality of the negotiations needs also to be guaranteed. As an incentive, we have some benefits to give to the cartelists that agree to admit their involvement in the infringement, or that they do not want to discuss the existence of that infringement with the Commission, and so they accept the situation. So we have to, in order to consider how can we improve the use of settlements, we have to consider this instrument, this tool, within the competition law enforcement toolbox of the European Commission. We see that the European Commission and many other competition authorities have different tools to fight against cartels and to fight against other infringements of competition law. We have compliance programs, whistleblowing, private enforcement. We have leniency, commitments, and finally, we also have settlements. I have stressed the relationship between leniency, commitments, and settlements because, from my point of view, these are the three tools that are more linked between themselves. The relationship between commitments and settlements in the European Union is, fortunately, quite easy, since the European Union only accepts a commitment decision for non-cartel cases, and settlements are only suitable for cartel cases. So there is not any overlap at all. Even when there are some national competition authorities that have designed their settlements proceedings in a way that they do incorporate the need to assume some commitments, for example, to compensate the damages or to adopt certain conducts in order to avoid further infringements. But from my point of view, the most interesting relationship between tools in the European Union is the relationship between leniency programs and settlements. Because in the European Union, we have a twofold system that implies that parties may use leniency and settlements. And this is very different to what happens, for example, with the antagonical model, which is the one of the United States. In the United States, we have one-fold system in which the parties only have one despite the ones that have claimed for the immunity because they are the first confessing the existence of the cartel, there is only one proceeding to negotiate with the authority. In the European Union, instead, we have these two possibilities. First, you can claim for leniency, and along with the leniency, you can admit your guilt and enter into a settlement agreement. If we want to ask what kind of tools, enforcement tool, are settlements, we have to say that it depends. It is a multifunction tool, and it depends on the way every competition authority has designed this instrument to see how does it works. We may see that there are many differences between jurisdictions. The first two ones are the most relevant ones. The first option is to design settlements as an open negotiation or just as an streamlined procedure. The first option is the one, for example, taken in the United States, and the second one is the one of the European Commission. In the United States, party may negotiate with the authority on almost everything. They can cooperate. They can. We do not have a list or a concrete definition of what parties may offer to the authority. So we have a broader scope of cooperation. Instead, in the European Union, we have a very limited possibility to contribute to the authority, because the parties and also the authority are very constrained to what they can offer. The parties may only offer to the authority during the settlement discussions the admission of the infringement, and the European Commission may only offer them a fine reduction of 10%. This is linked with the second possibility to configure or to design settlements, which is the distinction between the use of settlements as an investigatory tool, as it happens in the United States, where parties may use these conversations, these negotiations, to offer different proof of evidence about the infringement or other further infringements, or the situation of the European Union that is just a tool to accelerate the procedure. Here we are facing what is the relationship between settlements and leniency, if we have only one system or if we have two. Okay, this is a very different classifications. This is very different criteria that may be taken by the different national authorities or different competition authorities. We can also see that those systems that allow settlements only for cartels and others that also admit settlements in other cases and so on. But this is not the crucial point of my presentation, so I don't want to steal much time, and I go to the central point of it. From my point of view, and despite what is stated in the Regulation 622 and in the settlement communication, the settlement notice, the European Commission does and should be able to bargain during the settlement negotiations. I mean, the Regulation 622 established that the European Commission would not bargain with the parties on the facts of the infringement, as the only reward for settling could be a reduction of the potential fine of 10%. However, the European Commission has somehow, and we are going to see some cases, started to admit some kind of negotiation on the infringement during the settlement meetings. And also the parties, the cartelists, think that they have the possibility to clarify the terms and somehow influence the authority in order to get a better output of the file, a better output of the proceeding. What is the proper scope of negotiation? If we go to the theory, to what is the legal base, this scope of negotiation is very limited, since the European Commission lacks of any flexibility to improve the offer it makes to the party during the negotiation. If the settlement is admitted, it has to confer a 10% fine reduction, and if no settlement is achieved, no reduction at all. But we cannot change this. We cannot give a fine reduction above this 10% or below this 10%. So the possibility, the real possibility to change the offer of the European Commission is not existing. However, during the negotiations, the parties may influence. They may change the assessment that the Commission has made on the infringement, and this change on the assessment may influence, may have an impact on the result of the proceeding. For example, we may conduct, or we may reach to a narrower definition of the infringement. We may convince the Commission that our intervention in the infringement has been lower than the one it was supposed to be, and so on. This negotiation, that in my opinion is possible even when limited and should be improved, should be enhanced, has certain limits. The first limit to this possibility to negotiate are those facts that are already documented in the information or in the evidence that already is in the file. And also,
excuse me, you have another 2 minutes.
Yeah, I go on. Just 1 minute. Okay.
2 minutes.
And perfect. And also we have to respect the principle of equal treatment. So there cannot be any discrimination between the parties. Which extents can and may be discussed. For example, the determination of the basic amount of the fine. The European Commission may not decide to increase the 10% fine reduction or to reduce the 10% fine reduction, but we may change the basic amount of the fine. Also, the definition of the different elements of the conduct that have been taken into account when determining the fine. Also, we may influence during the settlement discussion on the exact percentage of fine reduction for leniency second commerce. For example, if we are the second commerce in a leniency program, we have a range of reduction that the Commission may confer us. So if we are in the top, in the upper, or in the lower limit, could be also influenced during the negotiation of settlements. I mean that it is very important to allow the parties to this room to negotiate, because they do not have the possibility to challenge or to oppose to the statement of objections. And this negotiation is quite a dark place to investigate, because it escapes criticism. As it must be, all settlement discussions are covered by secrecy, and all the information and all the content of this negotiation are confidential and should not be disclosed. So any decision that the European Commission takes during these negotiations is secret, and it's very difficult to be assessed or to be considered from the outside. And also the negotiations taken by the European Commission and the parties do not create binding precedents. So the European Commission, in fact, even when the legal base does not admit so, has a very important way to work. And finally, and this maybe it's one of the most relevant part of this work, I have identified some cartel cases in which we may see how actually the European Commission is negotiating with the parties during the settlements. For example, in the cartel of the waste management products, the European Commission considered that a certain part of the cartel period was a period of limited activity. And as a result of the negotiation, in the final decision, the time duration of the cartel established by the European Commission was only 6 months, even when in the first assessments, the cartel was supposed to have lasted for almost 2 years. Another very interesting case is the case of the paper envelopment cartel, in which, with the negotiation with the different parties, the European Commission could realize that one of the parties had a lower participation, a lower intervention in the cartel, and it granted a reduction of the fine as a mitigating circumstance, along with the reduction for the settlement. Also, in the CRT glass cartel, we have a definition of a partial involvement of 2 cartelists. And also it's very interesting the case of the refrigeration compressors cartel, in which one of the parties, Embraco, could not benefit from leniency, but obtained a further fine reduction for the greater cooperation provided during the procedure. This is very interesting because Embraco was late, could not cooperate with the authority during the period to offer leniency applications, and after that, during the settlement, it gave some evidence and cooperated with the authority. And this cooperation was, however, rewarded by the authority by giving a reduction of the final fine of an 18%, even when it didn't have any right at all to get a reduction under the leniency notice. And I'm sorry to have been so fast. Thank you very much for your attention. And if you have any comments that we cannot discuss today, here you have my contact data, and I would be very glad to have your feedback. Thank you.
Thank you so much, Kenny. I think we have a question of Ruprecht.
Okay, thank you very much. Thank you, Henry, for the interesting presentation and the interesting project. I actually have two questions, and I give you the easier one first. The easy one is, looking at settlements, do you have any problem with sort of the lack of judicial review? Because I sometimes interpret settlements as an easy way out for the European Commission or the competition agency to avoid judicial review of the case. That is the first question. I can give the second one right away too. I find it very interesting that you look into the sort of negotiation processes and the parameters, how this is structured. And I wondered, what would be the yardstick for saying that this is a good process or a good negotiation or a fair settlement process? And I wonder, settlements are sort of based on the idea that it's a win-win situation for both parties. The Commission and the undertaking sort of both have to get something out of that. On the other hand, we have the public interest that should be pursued normally. So other parties are probably not part to the, or maybe not everywhere part to the negotiations. And also I wonder whether fairness or whatever is the right standard for assessing what makes a good settlement process. Because if you look into the differences in the different regimes, I mean, the next question will definitely be, okay, what is the ones that sort of are more either effective or lawful or better than the others?
Okay. Can you answer briefly?
Yeah, I would be very brief because he has already to talk and it's very interesting. So with the judicial review, I do have a problem, but not so much considering the European Commission proceeding, but considering the possibility of incorporating a settlement proceeding in other jurisdictions. For example, in Spain. In Spain, we still do not have a settlement proceeding, but we are considering to introduce it. In Spain, we have the very large problem that a large amount of the cartel decisions are challenged in court, and the court reduces the fine normally in a broader way. That is, if you accept the settlement, you will get a 10% reduction. But in Spain, if you do not accept the settlement, even when it is not, and you go to court, you may get a 25%, a 30%, or a 50% reduction. So in my opinion, and in some cases, you can see that the cartelists have to decide what is their strategy in order to get the best of. This is very interesting, the part of judicial review, but I am going to pass to the second question that is much more difficult, but also more interesting. In my opinion, to make a good settlement proceeding, and especially taking into account the system in the European Commission, we need to leave a bit more of a space, to leave more room to negotiate with the European Commission, because currently the time saving that we are getting is very limited. In most cases, the difference between handling a case on a settlement proceeding or under the ordinary proceeding is just of 6 months, maximum 1 year, the time that we can spare. And also we have the very large problem of hybrid cases. Hybrid cases are situations in which the win-win situation is lost completely. And so the European Commission is suffering all the burdens and all the costs of the whole proceeding, and some of the parties gets a good exit. And also in the hybrid cases, which are to be taken into account, in many cases, the party that has not settled when challenging the decision gets a better output than the party that agreed to the settlement. And so this can also be an interesting point to take into account. Thank you very much, Robert.
Okay, thank you very much. I think there's also very stimulating discussions in the chat directly. So, so please also that everybody looks at the chat. We still have now another presentation now from Ruprecht, and I'm very curious.
Sorry, I wonder whether Eugenio wanted to answer the question by Penny, because it eats into my time. I'm interested in the answer. So Wolfgang, if you, but I'm in your hands, obviously. Okay, I try to share my screen now. Sorry, Eugenio, for putting yours away. Okay, hi everyone. I take that as Wolfgang's acceptance that I take the floor now. Thank you, Wolfgang and everyone. It's great to see so many familiar names and faces, and it's such a pity not to be able to have a drink with you after this, or only virtually. But anyway. I'm going to talk about the institutional triangle of how to reform competition law. And the starting point for this is that many in our community share the feeling that it's a need sort of to tame the tech titans, whatever you may call that. If you're like, I would identify myself as a progressive antitrust scholar, others may call that a hipster or Brandeisian or whatever scholar. But if you have that idea and find out that current systems don't work well enough, you probably need a change in the law. And what has been sort of in the discussion very much in the past, well, basically weeks, is an ex-ante tool for competition authorities to regulate the gatekeepers. I imagine this tool to be sort of the opening door to the gatekeepers ecosystem. Actually, in Germany, the debate has been moving on a bit faster than on the European level, where we only for a couple of weeks have this idea of a new competition tool, as the EU Commission calls it. And the German debate has very much focused on, there is a German draft bill on the table ever since January, and there is a section 19A, Wolfgang has referred to it this morning in his talk, I think, that addresses undertakings with a paramount significance for competition across markets. And it is something, it's not really an ex-ante tool for regulation, but it is a sort of new competition rule that shall achieve some change, and it is a legislative change. I was pretty much involved in sort of thinking about this and in the German debate that was going on, and looking at this and wondering what could be of interest to the ASCOLA people. I asked myself, okay, if I look at this, what are really the conditions if we want to reform competition law for change? So what conditions do positively impact change? And in order to do that, I thought it's not sort of only focusing on the substantive material issues, what we put into the law, but we probably also have to look into it from a broader perspective. How do we achieve change? And so the general idea was to strip everything of the material substance, of the intrinsic value, of the intrinsic legal value of the rules that we are discussing, and focusing on the purely institutional perspective of legal change in competition law. That was basically the idea of this, or is basically the motivation for my paper. And of course, you could do that with democratic theories, with political research, etc. I decided to turn to a Nobel laureate in economics because I thought this is what all of you are sort of praying to every night, looking up to these economists, and I thought that is probably the right benchmark for a talk like this. And the guy I found is Douglas North. Most of you will know him as the sort of inventor of new institutional economics, and I refer basically to a sketch. It's not really a model or a theory, but a sketch by him from 1994 called Institutional Change, a Framework of Analysis. Talking about this with Wolfgang Kerber present is a challenge. I've also seen Oliver Budzinski. Both of them are heavily into institutional economics, so please bear with me. just very briefly, let me introduce to you what North sort of, how North analyzes what's going on in change. The paper that he wrote that I'm referring to is on the economic policy in the United States in the 19th century, so how things developed there. And he uses certain terms, certain terminology, like institutions, transactions, structures, orders, information, etc., to simply say this is what happens. And so he names certain things that you know by other names with this very specific institutional economics terminology. So what happens usually when we're talking about economics is that there are transactions. These transactions, this is the magic cross in the middle of that, of these two people, original pop art by Keith Haring. No, it's only my PowerPoint skills, but anyway, and this is sort of a stream of information coming in. So the transaction is heavily influenced by information, people doing this transaction. But these people, of course, adhere or need to adhere to certain institutions. Institutions are basically the rules of the game. So competition law is, in the view of or in the terminology of institutional economics, is an institution, as is precedent, as is all sorts of other factors that influence your transaction and your capacity to transact. This is what I would sort of see as the green circle around these people. They are bound by institutions that define their behavior. Why do we have these institutions? We have these institutions usually to reduce transaction costs and to reduce the uncertainty when people get into action. So we come up with laws to reduce uncertainty, to put people into a stable environment. This stability is further achieved when institutions are sort of interconnected to build structures, and several structures are then building basically the legal order. This is sort of the very brief introduction to that. What I found interesting when reading that was making it clear to myself that actually the existing legal regime that we have is an anti-change environment. It is built not to be changed. It is built basically to reduce transactions costs by providing stability and not to integrate change. And I think this is something that we always have to deal with as lawyers, that the law is sort of has difficulties in integrating new things. Now, what are the new things that we need to integrate? What are the drivers of change according to North? According to North, change happens if entrepreneurs, and this is basically everyone who's active, not just in our sense of the word, perceive an opportunity to gain at the margins. And this is an interesting statement because change is not provided in this view. Change of formal rules in particular is not driven by changes, but by external events or shocks or whatever, but by the perception to gain, or by the perception of opportunities. And this perception, of course, is shaped by external events, by new information, or by newly acquired skills. If we look at the whole endeavor of reforming competition law from this perception viewpoint, it becomes obvious that the inflow of information and the framing of information becomes a vital point. It's not so much the external shock of digitization as such, but it is how we think about digitization, who sees certain opportunities in that makes us sort of interested in change. Just as a side note, because institutional economics is so known for that, if we see this in information, we also have to see all the symmetries and problems with information, like biases, bounded rationality, etc. That's just a side note here. North also distinguishes between incremental change and disruptive change. Incremental change means there's a constant evolution in an adaptive system and a certain openness to integrate new information into the system and to adapt transactions to that. Disruptive change is, as he puts it so nicely, the outcome of an order that has lost the ability to compromise. And I had to think of this wording when thinking about our polarized debates. You may sort of know the works of Barak Orbach, who's writing on the drift in competition law and competition policy. Now, if we want to change formal institutions, which is our laws, we need to see the agents of this formal change, and I see this as the institutional triangle. The institutional triangle is composed by politicians, that is these guys. I have a very positive picture of a very positive icon of politicians here, the courts and the enforcement agencies. So this is sort of the institutional triangle. They can change competition policy and they can change competition laws, moreover. So I wonder, so how do these or looking from those, how do these actors in Germany come to a point so that they are willing to change the rules? And I found it quite interesting. So looking back into the reform process to see two things or three things in this. Looking at the politicians who are now siding very strongly with the new Competition Act in Germany, putting forward this Section 19A, that their change of information or their change of views was strongly influenced by media companies who started back in the 2010s or so, influencing them and putting forward the notion that they are losing out, so that there are there's a shift in perception of opportunities, and that was vital. I find it very interesting if I think in these terms to see that the German industry, that more traditional industrial companies, haven't even positioned themselves very strongly in this whole debate. They don't know what they want, but the media companies, the newspaper companies, etc., they are very actively pushing this, and they have, of course, something to give to politicians, namely good press for change, for in exchange to for changing the legal rules. So I think that this was a key driver for politics.
Ruprecht, you think a bit about your time?
Sure. Yeah. How many minutes do I have left? None?
A few.
This is sort of just an example of I'll skip that. Okay, looking at the enforcement agencies, what I found interesting to see was that the Bundeskartellamt was acquiring new skills very early on. They took cases with platforms, looking at platforms early on from the 2000s, and they have a strong track record acquiring the skills how to deal with platforms ever since the 2013 years, when they had a lot of cases coming up. And I'm stressing this because I think that this is a vital point for the Kartellamt to see where they can gain from these opportunities. The one who is not so adaptive to change probably are the courts. And that doesn't wonder if you read it with North's terms, because the courts are not so much into the debate. Judges have not much to gain because they're very well off already. Yeah, so there's nothing much to gain for them. They have little involvement in the debate. Information influx is very low, and the caseload with new cases is also reduced. If I now transfer this from the German debate to the EU debate, I think that we should really worry and maybe also reform what's going on the EU level. Politicians in the EU are probably are in a very different situation, so there's much more diverse interests. The courts have even less cases than the national courts, so they have one big case or very few big IT cases in the past years. And the same holds true for the European Commission. So the European Commission lacks the exact measurement because they haven't had the small and say insignificant cases to practice their skills. If your first big case in platforms is Google Shopping, you better do no wrong, which also means you cannot develop things in a constant incremental procedure, as can the national competition authorities. Finally, the question that North sort of answers is, will formal change deliver? If formal change does not deliver, say because maybe the courts sort of obstructed or their informal constraints, you can develop workarounds. The competition authorities usually do that by sort of not coming up with decisions, but with settlements or things like Eugenio talked about. So summing up, what are the conditions that positively impact change? And I jump to the second bit here. Get the judges into the boat, give the EU Commission the possibility to try and test and develop their new skills, and build a system that is more adaptive to change with the inflow of information. I think that falls neatly into the discussion of complaints as well. And I thank you for your time and attention. Thank you so much.
Thank you so much, Ruprecht. So this was a very ambitious project, really, giving an introduction into the theory of institutional evolution of Douglas North and applying this now to competition law, especially also German competition law. So are there any questions? I think Oliver Butinsky has a question.
Yes, thank you very much for this exciting talk, and I really love it that there's a positive view taken, positive in the sense of explaining view taken on the process, and not only a normative view on what the right content should be. The question is about the politicians and the incentives of the politicians. If politicians want to act because they get lobbied or because of other things, would they really try to reform competition law? Or wouldn't it be much more interesting from the self-interested view of politicians to ask for regulation and to put up sector regulation where they have a much more immediate effect also on the, if you consider the things that the press lobbied for, which was not really all on competition issues?
Yeah, very quickly, I think you have a point there. I think it's what the media companies did was sort of having or providing fertile ground for the idea that something has to be done. I think this is basically what happened after all the press publishers write a decision, etc. Now, looking into the more specific aspects, I think that you're right that probably for many politicians the personal gain would be higher if they had sector regulation. And this is even an idea which sort of is somehow on the table in Germany as well. I mean, I guess you're right. Yeah, of course, this is a very, very superficial model that I provide here, and so yeah.
Simonetta, you have a question?
Thank you. Well, thank you so much. I also share the view. It was a very nice view on what's going on, quite refreshing. So my question would be, based on your framework, okay, so we had a very, very big decision by a court that you are now considering perhaps out of normal developments, not getting informed, not knowing what's going on. So how do you then view this week's decision on Facebook by the Federal Court?
It would have fitted better into my presentation if they had decided the other way, to be frank. But it gives me some hope that maybe judges are also taking part in the debate, and maybe the Facebook case is an example for such a strong debate in public that even the judges sort of have to take a stand and are sort of more adaptive to change. You also have to see that the bench in Germany that has decided this Facebook case this week is composed by completely new judges. They are really, or not the presiding judge has been around for a while, but particularly the rapporteur of the decision, Patricia Rombach, she's new to the court. So are two others on the 5-people bench, and so maybe that also plays a role.
Antonina, you have a question?
Yes, thank you for a fascinating presentation. I just wanted to ask a question more methodologically. Do you see all of these actors as being entrepreneurs who have somehow see opportunities in the framework, or do you distinguish between some of the actors that actually are the entrepreneurs and the others? I'm more puzzled by courts being seen as also, if I understood you correctly, but maybe I haven't. So just what is the distinguishment of the set of the rules and the entrepreneurs, the formal constraints and the, yeah.
Good point, thank you. I think the term entrepreneur is sort of the term that North uses to describe actors of change. I mean, if you say courts are not actors of change anyway, I wouldn't agree with that, but if you don't see them as actors of change, you wouldn't call them entrepreneurs. But you shouldn't take the use of the word entrepreneur as being in the meaning of undertaking or something similar like that. And after all, I mean, the decision making in society and that bringing about may have thousands of entrepreneurs. I haven't said a word on our role, for instance, as academics in this whole endeavor. I mean, we play a role in this as well, influencing people or providing information, or the studies that had been undertaken. Also, I mean, we are entrepreneurs, maybe for change or against change, but I think the wording is sort of, you could probably discuss that in more detail. Actors is maybe a better word.
Björn? Björn Lundqvist?
Yeah, I could, my kids just left the room, so I can. Fascinating presentation. I liked it a lot, and I only had a comment. I mean, I think it fits quite well if you look at the changes to copyright regime, that InfoSoc, the new InfoSoc, where new rights for press publishers were introduced and so on. If you look more at like sector-specific regulation, I think the PSI directive, you can see lobbying there, quite successful lobbying, I think, from the large platforms that they retained the right to have some exclusive licensing to access public libraries and being the only one who's actually can digitalize that and so on. I think lobbying can be very successful actually on the EU level. Especially because we as citizens are not so keen to overlook actually what the politicians do in Brussels and so on. But great presentation. Thank you.
Maybe Wolfgang, if you allow me one comment on
yeah, certainly.
Of course, I fully agree, Björn, to what you say. I think that the interesting shift that we've seen in the past maybe 1 or 2 years is that if I think again in Douglas North's sort of patterns of perception as the important point, that we have sort of seen a shift from sort of the let me say dominance, even though of the GAFA companies in telling us how great everything is, to a more critical shift in public opinion, at least in some European countries or also in parts of the US. And this is sort of the interesting shift, obviously, or one of the shifts that we've seen. So if I say now here, okay, people have succeeded in doing that, I'm really only referring to the German situation, where I have the impression that the big government coalition is really siding with or against the GAFAs now.
Okay, I have questions myself at the end. I know, Robert, that you're also very much interested in evolutionary theories of institutional evolution. So you have North is a certain kind of theory, and I think you have explained very well. And but we also have other evolutionary theories which see more as that you design new institutions for experimenting with a new institution, and then other jurisdictions can learn from that. So in that respect, you have a kind of an experimental process. And I'm seeing as this paragraph 19a, for example, in German competition law, also as a kind of an experiment now from a member state, which perhaps the question is whether it's really legislated, is enacted. But in any case, it had already stimulated discussion, which has now perhaps also triggered a process on the EU level of really thinking about ex-ante regulation, and therefore seeing this also from this perspective, that we have different jurisdictions and there are interactions between them, and because this can also be seen as an evolutionary process. Perhaps you can comment a bit from this perspective.
Couldn't agree more, Wolfgang. I mean, this is the vital thing. I mean, this is not my idea, to see the European Union as a laboratory or as an experimental field with the member states trying things and then sort of harmonizing that on an EU level. I think this is a perfect example for that, and I think that the discussion on EU level about the new competition tool wouldn't have started if Germany hadn't sort of pushed so heavily into that direction. I sometimes, however, have the impression that, and this sort of, I wanted to sort of allude to that, that the European Commission sometimes doesn't have this, or let me put it nicely, the European Commission could be even more open and even more adaptive to what's happening elsewhere. I think I've also thought about that in the when we discuss priorities, where we sometimes have the impression that the European Commission sees itself sort of as the beacon of competition law, and it certainly is, and I will say nothing different to Margrethe Vestager tomorrow, but on the other hand, sort of learning from the others is a great experience, and they could even be more open to that. I think the openness of systems to integrate new information in an experimental learning lab, that's obviously what provides the best kind of change.
Okay, thank you so much. I think we have to stop right now. This was a great really panel with 5 great presentations, a lot of stimulating discussion also in the chat. I would like to thank everybody who has contributed to that. And in regard to the last presentation, I would like to recommend there is a paper of Ruprecht, who he details all the arguments much more precisely than he could do in the presentation. Okay, thank you so much, and have a nice next session.
Yeah, you can actually stay. This is the room where the next session is going to be. I actually see Dennis Carlton and I saw Steve Selleck just a minute ago. Hi, it's great to have you here, and we're waiting for Dan. So, you know, if you need a few-minute break, you know, we will start on time. So.